Hi there, it's Billie Tarascio with Modern Law, and it's been a long time since I just did a basic tip of the day. But looking back through my YouTube channel and the comments and what really engages with people, you guys, my subscribers on YouTube, really want to know about tips and tricks, and you're especially interested in litigation tricks. So I'm going to try to bring back the tips, the family law tip of the day, and if you don't want to miss any, you need to subscribe. So today, what we're going to be talking about is something that I just talked to a bunch of my lawyers about. Is it better to ask for permission or forgiveness from the court? So this question comes up all the time, and all the time we're asked to make this choice. Is it better to ask for um, the court to grant you the ability to move, the court to grant you the ability to move your things out of your house, the court to grant you to withhold parenting time because of X, Y, or Z? Is it better to ask for permission before you sell a piece of property? Is it better to just sell it? Is it better to violate the preliminary injunction? Or is it better to ask for permission and file a motion and wait for the court to see what to do? This is a tough call. And as a lawyer, it's a tough call. We have duties. We have duties to clients, to represent clients, and to protect their interests, and to give them competent legal advice. And then we have duties to the court, and we are officers of the court. We cannot tell you to break a court order. If a lawyer tells you to break a court order, they've probably committed an ethics violation. And our ethical regulatory structure takes ethics violations pretty seriously. So when a client comes to me with a very real question, Billie, if I don't sell this piece of property, I'm not going to be able to pay my bills. I've got a buyer. The market's hot. I need to sell this property. I can't give you permission. I can't give you my blessing. I can't tell you, yeah, do it. What I can tell you is, okay, let's go through the pros and cons of that decision. And then we can mitigate your risk. And this is a big deal because the family court moves slowly, right? So a lot of things will happen during the pendency of your divorce, and you may not be able to wait for a ruling. And so you have to make a decision. And that decision might be very uncomfortable because it may not be what you think the judge wants. And in general, I think people worry too much about what they think the judge wants. The judge doesn't really care what you do on a very detailed level. They really don't. And so if you have to make a decision for your life that is the best decision for your life, then you need to talk to a lawyer like me about mitigating your risk. Okay, well, how do we make this okay for the other side? How do we make this, how do we get an agreement? How do we make an offer that makes it clear to the court that we are not taking anything away from them? So for instance, we've got a client right now who there's a temporary order in place for the husband to have supervised parenting time, 2 hours, 2 times a week. He committed criminal acts and is probably going to jail and will never end up with custody of these kiddos. She is the primary custodial parent, and she wants to move. She wants to live in a different state where her job is. And moving would mean violating the dad's supervised parenting time. So this client was very upset, just freaking out because she used to have every other week with her kids and this ex-husband, and she used to be able to go and live in this other state and work every other week. And now she has to be here all the time because there's supervised visitation twice a week. What can she do? Well, we have to mitigate risk. So if it's best for her life, if her job is in this other state, if this is how she can pay her bills, if this is how she can support herself, if there's no other way to support herself, then by all means, you got to do what you got to do, right? So how do we mitigate the risk of the court? Well, we can reach out to the other side and say, look, we have to move. We can either file a motion for relocation. That's never going to get heard by the court in time for you to actually make a decision. And this is why it's really hard to know forgiveness or permission. And this is where mitigation comes in. So mitigation is reaching out to the opposing counsel and saying, listen, the client has to move. I know you've got 2 hours a week, 2 times a week. We instead would like to offer 4 hours a week on Saturdays and Sunday every other weekend. So you dad have the exact same amount of parenting time. You're not losing any parenting time, and my client still gets to do what she needs to do and move. So be creative. It's not either or, it's how do I make this work? And by coming up with solutions for judges and for opposing counsel that really does consider everybody's interests and make sure that everybody's needs are met, you're much less likely to be held in contempt, and you can still make the choices that you need to make for your life to work. Because her moving is not actually contempt. Her missing supervised parenting time for the dad could be contempt. But if contempt is willfully not complying with an order, and so if you come up with a defense like impossibility, I couldn't do it, I couldn't stay here, then you have a whole lot better chance of not getting in trouble with the judge and being able to live your life and make decisions. So forgiveness, permission, or mitigation, all things to talk about. And if you're stuck, talk to an attorney, talk to somebody like me, talk to a creative attorney who can help you come up with solutions. That's it. Don't forget to subscribe, and we'll talk to you soon.